Hello everybody, I'm Seth Weissman and welcome to another episode of Safe Real Estate. Today we are going to talk about when should the seller agree to allow the contract to be assigned. And as we all know, the GAR purchase and sale agreement provides that contracts are not assignable unless the seller consents to the assignment. But a lot of buyers will put a provision into the special steps allowing the contract to be assigned in the discretion of the buyer. And the question is, should the seller agree to that? My general answer is no. If I were selling a property and the buyer included a special stip giving the buyer a right to assign the contract, I would generally wonder if I had priced my property too low. Because if the buyer wants to assign it, to me that's a signal that they're looking to flip the property. And obviously if they're flipping it, they're going to be flipping it for a profit. So I would not be inclined to want to agree to an assignment provision, with one major exception. In commercial transactions, it is very common for the buyer to initially purchase the property in an individual's name and to then create a limited liability company or a corporation and to assign the contract to that legal entity. I am fine with that happening in commercial, and frankly, it does occasionally happen in residential transactions. And I would just make sure that when that occurs, that the buyer is a significant owner of the company to which the contract is being assigned, which is actually what our commercial purchase and sale agreement already provides. But again, as a general rule, I would not be inclined to agree to an assignability provision, because again, I think it signals that maybe this is a buyer who is looking to flip the property. I hope this episode of Safe Real Estate has been beneficial. As always, it's great to see everybody. Thanks for tuning in. Bye now.